Agus, I very much welcome this bill. It's a hugely significant piece of legislation. Indeed, it's one of the longest pieces of legislation that has come before us. Yesterday we were dealing with one of the shortest pieces of legislation in relation to getting rid of charges in hospital, and this one has 268 pages, 10 parts, 293 sections and 7 schedules. The explanatory memorandum alone is 58 pages. So I welcome it, and I want to acknowledge the huge work that has gone into the preparation of this bill. I want to acknowledge that there was pre-legislative scrutiny, because very often I stand up here and I condemn the fact that there wasn't. There was, so well done on that. As usual, I want to thank the library for their work. And I want to thank the committee who published a report. I think, Chair, you were on that committee yourself. Now, having said all of that, and I want to just say what the Ombudsman, the Garda Ombudsman Office, they are on record, as are the Irish Council for Civil Liberties, for welcoming the bill. And the Garda Ombudsman says it represents a significant step forward in addressing a clearly defined and long signalled gap in Ireland's policing accountability infrastructure. So that's a very delicate way of putting it, and in particular we welcome provisions in the bill that strengthen the independence and both expand and clarify the remit of the Office of the Police Ombudsman. So all of that is very positive. However, GSOC will go on, and in the time I have, I'll come back in more detail, but just to highlight from the outset, they have ongoing serious concerns. The bill misses the opportunity to embed institutional independence in the new body, as envisaged in the Commission of the Future of Policing, which was published back in 2018 and as set out in the Council of Europe's Venice Principles. Full institutional independence should, in our view, be the fundamental foundation upon which any proper oversight body is built, and in the absence of which is likely to diminish the status of the office. Now, I think these are concerns that should be taken on board, and the concerns have been also expressed by the Irish Council for Civil Liberties. Number 2, the bill requires the Office of the Police Ombudsman to perform its functions in a timely and effective manner. Very, very welcome, and a good obligation. But there's no quid pro quo here. It does not require a corresponding obligation on other key actors, not least on Garda Síochána in their dealing with the police ombudsman. And if the new police ombudsman is to succeed in fulfilling its expanded remit, it will require a significant amount of resources. That's important as well, which I'm going to come to in a minute, because repeatedly every year annual reports, the GSOC have highlighted the lack of resources. As mentioned, it was identified as necessary by the Commission on the Future of Policing, and the target date for the implementation of those recommendations was last year, so we're now behind schedule, but it's going through this year. The bill will repeal the Garda Síochána Act 2005, which at the time was a very significant piece of reforming legislation. That act provided for the establishment of GSOC and the Garda Inspectorate. Now, what did it come on foot of? What forced that change? It came on foot of the Morris Tribunal. Last time I looked at that, it was 70 million cost and rising for this establishment to draw the conclusion that that level of corruption and significant problems was just based in Donegal. We failed to learn from that. It said that the Garda Síochána Complaints Board was ineffective, and that had been set up as a result of the Kerry Babies Tribunal. The bill comes on foot of almost 4 decades of serious Garda controversies and reactive efforts at reform in responses to different crises, always reactive, never proactive. This is the first time we're going to look at passing proactive legislation, but with significant problems still in terms of accountability. 39 years ago, I think approximately, we had the Kerry Babies Tribunal, and I really would invite everyone to read A Woman to Blame by Nell McCafferty, which has stood the test of time in relation to that, and where a tribunal was set up to investigate the police, and it ended up investigating an innocent woman and holding that woman to account, which wasn't the purpose of it at all at the time, and just an absolutely shocking indictment of the system, the tribunal, the all-male judge, solicitors, barristers, guards, inspectors and superintendents, not a woman in sight, as they held an innocent woman to account. It led to the establishment of a new it led to the establishment of the Complaints Board, which was subsequently found to be totally inadequate. The bill provides under 3 headings, as you well know, provide for a new governance and oversight framework for policing, the establishment of the Office of the Police Ombudsman to replace GSOC with an expanded remit, the establishment of a new Policing and Community Safety Authority, which will merge the existing Garda Inspectorate and the Policing Authority. A whole section in relation to security. For the first time, we're going to have the Office of the Independent Examiner of Security Legislation to strengthen national security remit, which is very welcome. But again, and I'm no expert, but I take the expertise of the Irish Council for Civil Liberties and GSOC, who have highlighted the failure, the gaps in this area. And of course, then we're looking at community and a whole of government responsibility. And again, I welcome that, but I tremble, because when we make something a whole of government response, as with housing, as with climate change, we end up not meeting targets. So a whole of government response is very welcome, but how do we make sure that that's operational on the ground? Placing an obligation on departments and other public bodies to communicate, cooperate and communicate. So I'm not sure I'll have enough time, but I'm going to briefly just look at 39 years of Garda controversies and the reactive efforts that have led us here today. As I mentioned, with the Kerry Babies Tribunal, which led to the establishment of the Garda Síochána Complaints Board, which was not effective, to put it mildly. We had the 1990s, 2000s, the Morris Tribunal. Let me refer to what Justice Charlton has said about the Morris Tribunal, and he's still ongoing in his disclosures. This, he says, in relation to this is the 3rd interim report of the Tribunal of Inquiry into Protected Disclosures. He says, this tribunal is about calling the police force to account. The Morris Tribunal was about the same thing. The Commission of Investigation conducted by Mr. Justice Kevin O'Higgins, which was my first introduction to the Dáil in 2016, was about the same thing. And he goes on, and he says, it was about the same thing. Central to these inquiries has been the truth. The Gardaí offered no criticism of themselves. I admit I'm picking and choosing comments, and let me balance it by saying that the police force is a resource of brilliant men and women. He acknowledges that, absolutely, but he also sets out that management and certain elements of the Guards utterly failed to reflect on themselves or to change. How dispiriting it must be for these very good men and women, he said, what is detailed in this report. They are crying out for leadership. A cultural shift requiring respect for the truth is needed. Central to these problems is a mentality problem. Where a problem occurs, strongly self-identifying organisations can have a self-protective tendency. It is beyond a pity that it took independent inquiries to identify obvious problems with what Maurice McCabe was reporting and the service that he has done to this country. I don't think we can mention his name often enough. He goes on to talk about the difficulty of extracting the truth. And it's worth quoting what he says about that. In relation to the matters at issue in these reports, it has been a dreadful struggle to attempt to uncover what may have gone on behind closed doors. Again, I admit I am selectively choosing from this, but they really are worth reading. Public relations, he said, speak as a substitute for plain speaking in an affront to the duty of our police force to be accountable. The correct approach for an organisation is to enable those who are expert on a subject to speak on its behalf. There's a lesson there for all of us, and certainly for the government, about public relations. And very helpfully then, Charlton goes on to tell us the obligations on Gardaí. The first obligation is to take a pride in their uniform. The second obligation, can you imagine, is a duty to be honest always, to be visible, to be polite, to serve the people of Ireland. And again, that applies to all of us as public servants, applies to the local authorities in particular, who have forgotten the management, who have taken on the corporate mantle that they're there to serve. But in this situation, it's in relation to the Guards. And the sixth obligation of the Guards is cast on the organisation as a whole. The organisation must treat their obligation to the public sector, to the public, as superior to any false sense that individual policemen and policewomen should stand up for each other. Do you remember all of that going on with Sergeant McCabe? The seventh obligation is self-analysis. It should not be necessary to have a Morris tribunal or the other Higgins or his own to have self-analysis, self-reflection and discovery. What has been missing in the past is the command structure of An Garda Síochána calling itself to account. So that's just from that report, and that's only one of the interim reports in relation to this. Remember former Commissioner Callanan's accounts before the Public Accounts Committee, and that space between the coffee bar upstairs and going downstairs, where I won't repeat the comments he made about an innocent man, whispered into the ear of the Controller and Auditor General, which subsequently became public at the tribunal when the Controller and Auditor General attended. We had a Cook report about the bugging of the GSOC offices. There was no evidence of bugging found, but a very poor working relationship between the Guards and GSOC. We have a Fennelly Commission and so on and so on. Then we have the revelations in 2017 of the falsification by Gardaí of breath test figures, which resulted in possibly 2 million bogus breaths, although the true figure may never be known. Same year, 146,000 incidents of people being wrongly summoned to court to answer fixed charges, and so on. Then we have the establishment of the Commission of the Future of Policing, led by Kathleen O'Toole, who came up with some very good recommendations and analysis, and this bill, belatedly, is one of those recommendations. We have in 2022, just in case anybody believes this is historic, we have publication of the independent review commissioned by the Policing Authority into the cancellation of over 200,000 emergency calls, 3,000 of which related to domestic violence. So that's some of the background that has led us here today to this mammoth bill to bring openness and accountability. Now, if we've learned anything, it's to actually, and I've praised you for bringing this bill, but the committee amendments are very important. If you're seriously committed to acting on all of these tribunals and making it open and accountable, the police force. The GSOC have repeatedly pointed out year after year after year, 2007, 13, 14 to 17, their annual reports. I don't have time, but they repeatedly pointed out we do not have enough resources. I've heard various TDs in here criticise GSOC wrongly, in my opinion, because if they read the annual reports, you'll see they have cried out for resources over and over and been utterly ignored to a certain extent. 18, annual report, there was finally sanctioning of some additional staff. What did they identify as a strategic risk? Lack of resourcing. Lack of resourcing, and they continue to do that. 2021, in case you think I'm going back too far, there's the most recent one available. A perennial factor is resourcing. I have a whole paragraph on it here. Time doesn't allow me to go into it. So that's where we're at. So what have we got now in this bill besides the overall? The concerns. The concerns are in relation to quite a number of sections. Sections 179, 180 and 181. The Office of Police Ombudsman said they should lay their strategy and their annual report before the Dáil, rather than involving a minister who would then lay it before the Dáil. That's in keeping with good practice and in keeping with other agencies. In relation to making complaints, section 192, you've put in a review by a minister who, that minister, he or she will then decide whether this is necessary at all. So no later than 3 years after coming into the operation of this section, where all complaints made to a member of the Garda go on to the Ombudsman. He'll review this, or she will, and decide if some complaints do not need to go. So what's pointed out here, it goes against the recommendations on the Commission on the Future of Policing. Remember why that was set up? They recommended that all complaints about the police should be put through the Ombudsman's office to determine what actions needs to be taken. If you leave this section as is, it's interfering with the independence, the very thing that you're supposed to be strengthening. Section 203, investigation of matters related to the Garda Commissioner, will require ministerial approval. Good Lord. This is not in keeping with the recommendation of the Commission on the Future of Policing. Section 207, in relation to search of Garda premises, must obtain a warrant. That's very welcome, but it must be approved. The search must be approved by the Garda Commissioner prior to the application to ensure there are no state security issues. Where the Garda Commissioner objects to the search of a Garda premises for reasons of state security, that very broad, nebulous concept that can be used as elastically as we want, is a huge problem for me, but more importantly, a huge problem for GSOC and the Irish Council for Civil Liberties. Section 207, 15b, death of or serious harm to. GSOC is concerned that this provision is limited so narrowly to death or serious harm and does not cover criminal activity by the Gardaí, such as corruption. Section 221, review by the OPO of its own decisions. This review should be carried out by a person independent of the decision. Again, I mentioned already that the bill, rightly so, requires the Office of the Police Ombudsman to conduct investigations in a timely manner, but there's no corresponding obligation on other agencies, particularly the Guards. Other issues? Incidents of concern. I understand that the pre-legislative report recommended that incidents of concern be more clearly defined. Section 109 defines incident of concern as where Gardaí may have committed an offence or behaved in a manner that constitutes notifiable misconduct. Again, GSOC and the Irish Council for Civil Liberties have concerns that the remit of the Office of the Police Ombudsman is limited with regard to incidents of concerns. According to GSOC, and I fully agree with them, some incidents may be of relevance to public confidence. Absolutely, confidence and perception is hugely important in policing, but would not be notifiable or constitute misconduct. They say that all incidents of concern should be notifiable. And again, the Garda Commissioner is not required to notify the Police Ombudsman under Section 200, subsection 6, if it would be prejudicial to the security of the state. That's way too broad. I forgot in my opening remarks to pay tribute to Vicky Conway. And I notice here that Vicky Conway and Eddie Malai opposed the creation of the board that's been set up. But I mention her particularly for all her work, and also her work on the Policing Authority. She was a breath of fresh air and a voice for human rights, for proportionality and for equality, and she absolutely deserves our praise. The first board will be entirely ministerial appointees, with a lot of question marks that comes with that. The appointment of a commissioner, the new bill reduces the role of oversight bodies in the appointment of the commissioner. 1 minute left. I have a lot of concern about the proficiency or lack of it in the Irish language for the Gardaí atá I gcobar nó a bhaid I gcobar sna ceantar Gaeltachta. Section 33, the Garda Commission shall, to the extent practicable, ensure that members of the Gardaí, so on. So the extent practical hasn't really helped to date, because we know from the Commissioner Chonga's indictment of the failure to deal with Irish speakers in Donegal. It took him 10 years, and in desperation and frustration, that commissioner, who's now gone or about to go, or is gone, I think, had to lay the report before the Dáil to bring it to our attention. So now we're enshrining something that has utterly failed in the past. There's a change in the status of civilian staff, and I'm not sufficiently knowledgeable around this, but I note the serious concerns of the union and of the staff, and Forsa in particular, in relation to this aspect, which I would ask you to look at. The independent examiner of security legislation, again, there are some concerns in relation to that. And finally, the powers of prosecution. They were to go, as I understand it, from the guards. That hasn't happened in this. It's a missed opportunity. Perhaps the legislation is too big and it couldn't be included, but certainly I would like a deadline on when that necessary legislation is coming before us. Finally, I'll finish with human rights. The Code of Ethics. The Irish Council for Civil Liberties recommend that the Garda Code of Ethics should include a reference to human rights standards that is expected of Garda members and staff. They also recommend that it be made into a disciplinary code. Again, that's not included in the bill.